I call the honourable member Ian Lees-Galloway.
Well, Mr. Speaker, I think it's fair to say that I am somewhat surprised to find myself on my feet at this point. I would have thought that the government members would have had a little bit more to say about this important piece of legislation, but never mind. They're obviously giving somebody somewhere some time to go away and ponder the important and interesting probing questions posed by my colleague, the Honourable Pete Hodgson. I think they were excellent questions, and we would have. Well, Maurice Williamson said he prefers multiple choice answers. Maybe it's ACDC. I don't know. That's usually the answer that gets most people through fifth form, or it did back in my day. Fifth form doesn't even exist anymore these days, does it? But Mr. Speaker, we are on the third reading, of course, of the Trademarks Amendment Bill. And this is a bill that Labour originally introduced, and we are happy to continue supporting this bill. It's been described by Marion Street as an okay bill. It's not a bill that we're showing a huge amount of enthusiasm for, but it is one of those technical bills which is very, very important for ensuring that things keep happening, that our economy keeps moving, and of course in this age of the global economy and global trade, that New Zealand is able to participate in the global economy, both as a receiver of goods across our borders, and to ensure that the goods that we receive and that New Zealanders purchase within New Zealand are of high quality and as little as possible are counterfeit goods, but also so that we are able to protect our goods that we send offshore, as well as our intellectual property and our ideas and all the things that we send out into the world, as we too are traders in the global market. This was originally a Labour bill, and we are happy to support it. In fact, now it's been broken into two bills, which further New Zealand's commitment to building international trade rules, which we all know are vital to ensuring that trade is both fair and free. And we do know that in this day and age that people are much more conscious about where their goods come from, about the workplace relations, the employment laws under which people who are making those goods labour, and in fact by ensuring that they are buying the genuine article rather than a counterfeit article, people have a much better idea as to where those goods were made, who's making them, and under what conditions they are being made, and that's important to consumers these days. It's also very important to know that the environmental practices of the people, the companies that are manufacturing these goods are satisfactory and just, and people purchasing furniture. I used this example when we were talking about the NAPE bill the other day, that people purchasing furniture want to know that hasn't come from rainforest timber or some operation which is engaging in deforestation. They want to know that timber is sustainable, and that the other environmental impacts, the impacts of transport, the impacts of any chemicals which are being used, and all the other potential impacts of manufacturing any type of goods. People have a much better opportunity to trace those goods if they are the genuine article, the genuine trademarked article, as these bills allow us to enforce the treaties that ensure that those trademarks are robust. It will, as I said, enable innovative New Zealand companies to more easily protect their trademarks in multiple jurisdictions offshore. We do know that all countries and all companies do struggle in some jurisdictions to be able to ensure that their trademarks are protected, and that in fact the local government and local jurisdiction doesn't actually actively allow people in those jurisdictions to engage in counterfeiting. The bills enable the MED and Customs to more easily enforce criminal offence provisions by providing powers such as entry and examination without warrant, as well as entry and search under a search warrant. And actually I found Maurice Williamson's contribution to the debate most fascinating, where he discussed the impacts of counterfeiting and actually just the enormous level of counterfeit product which is available around the world, and the projected growth of that product, and indeed allowing our economic development and customs officials greater scope to enforce the provisions that these the provisions that we have to enable trademark and copyright enforcement is an important aspect in trying to curtail that international trade in counterfeit product. The bills expressly provide that the police have the same powers as enforcement officers, and that's an important aspect in that enforcement as well. It is important that New Zealand is playing its part and is leading some of the areas of standards development in this area. Obviously, as a nation which relies on trade, which relies on exports, that it's important that we're a leader in this field, and that we're seen to be a leader in this field. And harmonising our laws with international standards makes good sense. I think it is fair to point out that we're not exactly the first countries to be signing up to most of these treaties. Most of these treaties have long lists of states which are members of the treaty, even though we have been really practising the terms of those treaties for some time. It has taken us a little while, and indeed Pete Hodgson questioned what has taken us so long to officially ratify those treaties and bring them into law. Counterfeit trade can produce a significant amount of money that is attractive for criminal organisations looking to fund more serious illicit trades, and that's another important reason why we should be clamping down on this. As other members have discussed, we are essentially, by introducing these two laws, ratifying three treaties and protocols. The first is the Madrid Protocol, which provides a system that simplifies the procedures required for a trademark owner to protect their trademark overseas. Joining the Madrid Protocol will provide New Zealand trademark owners with the possibility of having their trademarks protected overseas by filing one single application for registration of a trademark with the Intellectual Property Office of New Zealand, and designating one or more overseas countries who are members of the Madrid Protocol where protection is sought. Overseas trademark owners would be able to use the Madrid Protocol to protect their trademarks here in New Zealand also. Joining the Madrid Protocol would also simplify the subsequent management of overseas registered trademarks. It is possible to renew or record subsequent changes to the trademark registration in each country using the Madrid Protocol through a single procedural step, rather than making a request directly in each country. The bill amends the Trademarks Act to facilitate the implementation of the international registration regime for trademarks under the Madrid Protocol, including providing for regulations to be made for the purpose of giving effect to New Zealand's obligations under the Madrid Protocol. So this is a streamlining process to ensure that people who want to register their trademarks internationally are able to do it simply, without too much fuss or bother. These things are never entirely simple, but this is a method of ensuring that it's easier than it might otherwise be. The other agreements that we are signing up to are the Nice Agreement and the Singapore Treaty. The Nice Agreement provides a classification system for goods and services for the purposes of registering trademarks, and the Singapore Treaty aims to make national trademark registration systems more user-friendly and to reduce the business compliance costs for trademark owners. So all of these are making the business of registering trademarks both here in New Zealand and internationally much simpler. They allow New Zealand to engage in global economies, and for that reason Labor is very, very happy to support the continued passage of this bill.